The Eastern Caribbean Appeal Court has upheld the ruling in the case involving Lindsey Grant and Janelle Powell for the misappropriation of $460,000, that's 1.2 million EC dollars, belonging to a client. Their application to overturn a default judgment of High Court Judge His Lordship Justice Eddie Ventos was also denied by the appeal court. Chief Justice Her Ladyship Dame Janice Pereira and the Justices Louise Blenman and Gerard Ferrara wrote in their judgment that the delay by Grant and Powell in making the application was inordinate. No good explanation for the delay was proffered, and any prejudice they suffered was of their own making in their lax approach to obeying timelines or seemingly uninterested in taking corrective measures, even when given notice of them. The appeal court judges said Powell and Grant failed to demonstrate realistic prospect of success on appeal, let alone a good prospect of upsettling the ruling of Justice Ventos. The appeal court heard arguments in the case on June 10th and 29th and denied the application of Powell and Grant for leave to appeal the interlocutory decision of High Court Judge Justice Eddie Ventos in refusing to set aside the default judgment against them and in favor of Mr. Tanzanian Tobin Tanzil. In the written judgment on July 6th, the justices noted that Powell and Grant, although well-seasoned attorneys at law, had failed to put forward any reason which may be given as good explanation, and why it took 13 days for the dismissal of an application by the full court to raise an application to extend time has been left wholly unexplained, the appeal court found. The court further frowned on what it said was a full-scale collateral attack by lawyers of Grant and Powell on the default judgment entered on the 9th of October 2018, noting, if ever there was an ambush, this was surely one and ought not to be countenanced by this court. The court agreed with Justice Ventos that although the $460,000 was paid by Powell and Grant after Tanzil had begun his court action, Powell and Grant have not shown that they have a real prospect of successfully defending the other aspects of the claim in respect to breach of trust, breach of fiduciary duty, failing to account, or misappropriation of monies belonging to the claimant, Tanzil. It does not follow that an eventual payment out of monies held by a trustee or fiduciary cures the breach of trust or breach of fiduciary duty, or that the monies may not have been misappropriated, or that accounting need not be given by the custodian of the funds in respect for the period the funds were so held. In short, the learned Judge Ventos has merely succinct in saying that these causes of action had not been addressed by the defendant. Further, when the draft defense of Powell and Grant was examined by the judge, the defendant's defense amounted to bare denial. Stating that this runs afoul of the rules of the court, the judges were of the view that the applicants have failed to show that Justice Ventos erred in his approach in his assessment of the draft defense. Interestingly, the judgment noted a request was made by Grant and Powell to suggest that they are facing the greater prejudice having regard to the nature of the judgment against them and their standing as politicians and members of government. The justices ruled that this is an irrelevant consideration in assessing prejudice in the context of this case. Before the court, all parties are equal and entitled to equal protection before the law. One class of person is not afforded some greater privilege and merits more consideration than another by virtue of political or ministerial portfolio, the judgment said. Powell and Grant were represented by Mr. Brian Barnes, Dr. Henry Brown QC, and Mr. Anthony Ross QC. Mrs. Angelina Gracie Suku Bob and Mr. Sylvester Anthony represented Mr. Tanzil Tobin. Andre Huey, SKN Newsline.